The Ministry of Defence faces legal action after a landmark court ruling that families of soldiers killed in Iraq can pursue damages under the Human Rights Act. The Supreme Court's decision follows a case brought by the relatives of servicemen killed and injured in Iraq, including 3 men who died while travelling in snatched Land Rovers. Our defence correspondent Caroline WYATT is at the court for us now. Caroline.
Well, this is the result that the MOD did not want. Its lawyers have fought hard for many, many years through the courts to limit the extension of human rights and negligence laws to the battlefield, which is an unpredictable place, which the MOD says is a place apart and where these sort of laws should not apply. But the persistence of several bereaved families and their lawyers seem to have paid off at this court today.
Sue Smith arrived at the Supreme Court this morning unsure what the country's highest court would make of her long legal battle. For Sue, the fight began when her son, Private Philip Hewitt, was killed in Iraq in July 2005, blown up as he travelled in a lightly armoured snatch Land Rover. She believes the MOD breached her son's human rights and was negligent in not providing better protection for him. But last year, the Court of Appeal accepted the government's argument that soldiers on the battlefield were beyond the reach of the Human Rights Act, which guarantees the right to life. But today, Lord Hope handed down this judgment.
The Supreme Court holds unanimously that in relation to the snatched Land Rover claims, Private Hewitt and Private Ellis were within the United Kingdom's jurisdiction for the purposes of the Convention.
For Sue and Colin Redpath, whose son Kirk was also killed in a snatched Land Rover, today marked a significant step forward in their legal battle with the MOD over soldiers' rights.
They can't just be out there with no equipment, or it doesn't matter. They've got to, as an employer, they've got to make sure they're safe at work, which is what should have been happening from day one.
This is a victory for the families who fought so hard on behalf of their brothers, fathers and sons. But it isn't the end of the story. What it means is they can take their cases back to the High Court. There, though, the MOD is likely to fight hard.
Today, the Defence Secretary Philip Hammond issued this statement. "I am very concerned at the wider implications of this judgment, which could ultimately make it more difficult for our troops to carry out operations and potentially throws open a wide range of military decisions to the uncertainty of litigation." The Supreme Court's ruling does extend the law's reach on the battlefield, also allowing negligence claims to be brought against the MOD, though the judges were clear that policy decisions made at a high level and decisions made in the heat of battle will not be open to legal challenge.
Well, all the claimants' cases can now go back to the High Court, where there are likely to be more legal skirmishes on the exact application of the ruling today. And before it's clear exactly the impact this will have on the MOD, whether that is for procurement decisions or training decisions or issuing orders ahead of sending soldiers, sailors or air personnel onto the battlefield. Simon.
Caroline WYATT, thank you very much.